Tumia link umejoin. Hebu join yangu waingie. Sawa. Join.
Just make an appearance as the
No, they are against me today, so that's why you have not seen me around. Now they are on the other side. You know, with your kind permission, there is a plea that is supposed to be taken. If that development can deal with it in 2 minutes, then these ones can leave and I can leave.
It's possible that this person will not be present here.
Very good. Patient of take off.
Zile mata pipi pia nasema lazima. Wadozo wanatolewa headquarters.
Wanaangua kujeni. Prosecution.
today there's no one. But they're here for you though.
No, they know. Salama. Salama. Yes. morning, Your Honor. For the first, second, third, and fourth suspects, my name is Danstan Omari. All the accused in the charge sheet, there are 4, 3 adults and a company. Probably if there is any other quorum, then I can address the court. Watching brief and others. Anybody watching brief?
Good morning, Your Honor. May it please the court. My name is Burage. I appear with Mr. Philip Nyachoti. And we seek to be placed on record for the family of the victim. He is on his way. There was a matter before the High Court directly related to this matter, which you shall be addressed on shortly.
For the statement, alongside the Melanic Senior this morning. We are before you to get the copies of the plea taken. Here's the accused persons are present in court. Perhaps counsel can let us know whether they are in the brief or if there's anything else so that we can read these applications.
Yes, thank you, Your Honor. The accused or the suspects are not before this court today. Reasons being they are on anticipatory bail from the High Court. The High Court ordered as and when the state decides to charge. The High Court ordered that when the state will decide to charge, they serve counsel for the accused. In good time to bring the accused before the plea court. I was served with a charge sheet on Thursday. I was served last week either on Wednesday or Thursday. By the investigating officers. We agreed if I get the accused, I take them for processing. On Friday. accused were out of town. I managed to get the accused today in the morning. And told them that they are required to take plea. That is one of the reasons why the accused are not before this court. Secondly, since I was served, we have been on long vacation. For those of us who are Omari Muslims, we had other engagements other than this that are personal in nature. Third, Your Honor, the accused filed a petition HCC HR petition PET stroke E004 stroke 2025. Petition number E004 stroke 2025 before Kibera High Court. Challenging 6 issues. 1, one of the accused is a military doctor. A very high military doctor. Very well. Let me leave there. In summary, that petition is coming up for hearing tomorrow. And it seeks to stay the proceedings and plea taking. You know, it is my humble prayer that the court defers the plea until the High Court deals with that question tomorrow. And we take a mentioned date for plea taking on Wednesday. Until Wednesday, so that the High Court, once the High Court pronounces itself, we will appear before you on Wednesday. Oh, sorry. Your Honor, my mind is that today is Monday. Thursday. Because the matter is coming up tomorrow, Wednesday. We appear before you on Thursday to tell the court whether the plea is to be taken, and that day the accused shall be present before this court. That's all, Your Honor.
Procedural application, I will be seeking leave of this court on behalf of Mr. Philip Nyachoti and myself to participate in these proceedings for and on behalf of the victim in line with the Victim Protections Act, under the caveat that I shall not, and Mr. Nyachoti, take any steps or usurp the role of the prosecution in any way pursuant to the decision of the Supreme Court in Republic versus Waswa. Your Honor, in brief,
Your Honor, before that line is taken, this is a matter of the state. It is a prosecutor to present his case. What he will not cover, the victim's lawyer will cover. There is no way counsel has admitted the Waswa issue. He comes after the DPP has prosecuted his matter. Not him prosecuting, then the DPP fills gaps.
Warrants for arrest issue against the suspects who intentionally failed to attend court. Defense counsel is not being honest to this court. And I believe the court may have just denied from his own very submissions this morning that he was not able to reach his clients up until Friday or this morning?
I got them today morning.
Today morning. At the same time, counsel is arguing that he was able to file not only one, two applications before the High Court in the period between which this matter was brought for plea and today. You ask yourself, where did he get the instructions if he was not able to meet his clients up until this point? Secondly, what counsel has not told his court is that that application, the first one actually, did not stay the proceedings anticipated that are coming up before this court this morning. I believe counsel intentionally has not served the order in court for reasons best known to him. You have a copy. The same is in the judiciary portal. A reading of the same shows that the High Court did not stay proceedings. Again, counsel has, I don't know whether by error or design, misled this court that the second application is coming before the High Court tomorrow. Unfortunately, that matter has just been dealt with by the High Court this morning. Same has been set down. The previous one, the first application was application number. Yes. Yes. Yeah. Number previous one is the one you referred to where you are granted anticipated bail. Those orders are not granted, the matter has not been stayed, they are not stay orders. It has been given a hearing inter partes on the 8th of April 2025. That is a matter of public record, we will supply those proceedings. My lad and senior was attending to the matter in which those proceedings. You are referring to 8th of April 2025. The other application that my learned friend has referred to, where the parties were granted anticipatory bail, the council has admitted the fact that he was served and properly informed of today's date. We have filed an affidavit of service by the investigating officer, avowing to the fact that even the accused persons were served. The order referred to by defense counsel did not specify that it's only counsel to be served, but due to the public interest, we ensured that both counsel and his clients were served and were very well aware of today's date. Well, as a matter of practice, such kind of orders lapse once suspects are aware that they are due to take plea, and during the process of plea, the defense would then be required to argue fresh terms. In effect, what the accused persons have done today by failing to attend, they are in breach of the very bond terms granted to them by the High Court. The High Court in granting the bail terms did not anticipate a situation where the accused persons will determine at their own comfort when they want to take plea. In fact, the very orders allowed the investigating organs to continue their investigations, summon the suspects as when they deem fit in furtherance of the investigations. And inform them as and when they are ready to charge or otherwise. This we've done. The matter was settled last week on Tuesday. That was on the matter was in court on the 25th. Exactly 7 days later, counsel alleges that they were not given sufficient time. In fact, our argument is that it's not supposed to be sufficient time. It's not for their own luxury. This is a public interest case. We are talking about lives lost. So in summary, we are not buying the argument by counsel that his clients did not give sufficient instructions, yet they were available to give instructions for other applications other than taking plea. We therefore humbly pray that the bond terms
interrupted me when I was addressing the court. Yes, by Prosecution Counsel is the accurate position. I wish only to add, Your Honor, that the tried position in law is that evidence should never be tendered from the bar, and any party seeking to allege that there exists any order from any superior court affecting the matter before you should tender the said evidence and not refer to it from the bar. Your Honor, if an affidavit has been placed before this court which is sworn testamentary evidence of service, the said sworn testamentary evidence of service is taken to be the truth unless there is evidence equally sworn challenging the truths contained in that affidavit. And for avoidance of doubt, Your Honor, I'm making reference to the affidavit of service. And on behalf of the victim, we wish that the proceedings hearing go on as justice delayed is justice denied, the victim being the family of the deceased person who inadvertently or clearly is the suffering party to any delays hearing. And it is clear, Your Honor, as I sit down, that the accused persons, through their able counsel, are well aware what to do should they feel aggrieved by whatever decisions are made by this equally very able court. As they have been to the High Court, and have confirmed that they are still participating in proceedings there. to align ourselves with the Prosecution Council.
You have been served with a court document that clearly, and you have been told, the High Court matter has been dealt today, and there is a date given. You know, when you look at that direction, it clearly says the matter is coming up on 2nd. of April 2025 at 10 a.m. I have confirmed with another one that is original from the portal. This is history when the DPP misleads the court intentionally. It has never happened. I know the pressure the state has. To circumvent justice. That is why the Office of the Director of Public Prosecution will lie to this court. Blinded to get warrants of arrest. I don't know what they will say. Number two, Your Honor, I'll be seeking they give you court directions and proceedings of today in that matter. A second limb, Your Honor, it is about the affidavit of service by my good friend Chief Inspector Peter Kamau. Paragraph 2. It says that on 29th March 2025, I proceeded and effected the service to the respondent through mobile phone, I hope the court gets a copy. This is the only one I have been given. Is there any other? WhatsApp, which was successive. which more facts ought to be there. They have talked of WhatsApp. The screenshot with the blue ticks showing receipt ought to be attached there. Material proof. This is a chief inspector of police, a very high-ranking officer. He knows. The director of public prosecution. Simply to hoodwink the court to issue warrants of arrest. My brother, the state has argued that this is a matter of public interest. Yes, it is going to be the biggest matter of public interest to charge doctors that a patient died while he was on an operating table. I'm only qualifying public interest. It has never happened anywhere. Really? Okay, I will avoid that. I'll avoid that. But Your Honor, the message is a commercial political interest. Commercial political interests. Lastly, Your Honor, the state that the accused are not here, but they are not admitting that their lawyer is here. The lawyer is seeking for deferment of plea. To Thursday. Which is 24 hours from now. It is true there is no stay of proceedings in this matter from the High Court. That is the truth. Neither have we argued that there is stay. Our reasons for deferment are clear. And I had my own things to do before I could get my plans. Because there is no evidence they were served. I say I was served. And I find no merit in application. There is no summons given to you. My clients have not been processed. have not been taken. Which is procedure before somebody is arraigned to take plea. You want to read the mischief of the state? And dismiss the question of warrants of arrest? Present themselves on Wednesday at 3 p.m. On Wednesday at 3 p.m. No. To the DCI for the argument are brought. They will only come here if they are present.
Let the court to have noticed the demeanor of counsel pocketing his address the court. What is this something? That is why it's insisting on Wednesday and Thursday.
Your Honor, with your very kind permission, Your Honor. My name is Philip Nyachoti. I'm sorry I'm late because I was attending to the same matter in the High Court. They took quite a while on virtual hearing. I appear together with my rank friend, Mr. Morage, and Ms. Mayega, for the family of the deceased interested parties. You will allow me to address you once, my brother. May I?
Much
May I make? May you allow me? Will you allow me, will you allow me, Your Honor, just to make one or two only?
My good brother knows, and we are friends. He has no audience. He has no audience.
Your Honor, I'm guided. I'm guided, Your Honor. Thank you. Yes.
Perhaps it is demeaning for you to say that.
No, we make money by attacking the DPP. That's obvious. And the police.
You see, there's the public here. They might think what he's saying is true. As much as the court knows, especially watching Omari.
really come. Welcome. I have considered the application made by the defense, the reply by the prosecution, and the advocates watching brief for the victim. And the only issue here is whether the accused were aware of today's date. The defense says otherwise, and the prosecution says the other way. This is almost the second time the matter is coming up in court. The defense was aware that at the end of the day they were one day going to be charged. They should have moved to the High Court for other orders, but they kept quiet till now. They requested for a date at their own discretion, at their own speed. The defense, the prosecution has requested for warrants. To balance the wheels of justice, I do direct that the accused person do appear before me tomorrow at 9 a.m. for further directions. Now you can take your cameras away.
My clients of body design were investigated over the death of a patient. The file went to the DPP, and the DPP has approved 4 people to be charged. 1, a doctor, a medical doctor. 2, the owners of the hospital for the offense of manslaughter. This is a historical time in this country where doctors, if anybody dies on a table of a surgeon, if anybody dies in a hospital, the police will arrest that doctor, charge him. It is similar to parents taking their kids to school and they fail their exam. Then the teachers will be arrested for having committed a criminal offense. It is like advocates taking instructions. We lose our case, then the police will charge us because we lost a case. If you count the number of people who die in Kenyatta National Hospital and in all hospitals in this country, we are talking not less than 4,000 to 5,000 Kenyans dying daily. Out of that, 80% they are dying in hospitals. Are we now going to arrest every doctor? This is a matter that could have gone to the board, the medical board. We filed a constitutional petition that is coming up tomorrow in court, challenging whether professions are going to be criminalized. It started originally when buildings started collapsing, and the architects and the quantity surveyors used to be charged. They never got any conviction. Now we are seeing an attack on the medical profession. We are seeing an attack on owners of medical facilities. As I put it very clearly, this is a political commercial game. The state is hell-bent to push my clients out of business, but we have full instructions. We'll defend. It will not, even if they take plea, who is going to be the witness? Who is going to be the witness? Where does the concept of violentin and fit injuria apply? Somebody willingly decides to go to challenge God's creation and create your own design of your body. You sign forms, you agree, you take the risks, just like any hospital. When that person dies, then the doctor must be charged. We'll fight very seriously because as professions of this country, this has never happened. If the media wrote a story and that story did not reach the newsroom, is the journalist going to be charged for having not covered that story? We are looking at a serious attack on the freedom of professionals in this country. We shall be appealing to the Kenya Medical Practitioners Board and the Dentist Board to take up this matter, because this, as I said, is a commercial, politically instigated matter. You saw the office of the ODPP. There were 20 here. They want my client's warrants to be issued. They were never served. The court has listened to us and said that we produce our clients in court tomorrow at 9 a.m. and they will be there. There's nothing to hide about it. These are those many cases that people are charged and later you hear the state withdrawing under Section 87A. My good brother can say something. The licenses were taken. They have not been licensed to operate. As we are talking, we have complied with the directives of the board.
Senior, this is a matter that squarely falls within the armpits of the KMPDU, and we think that under the doctrine of the exhaustion, the ODPP has not exhausted all the available mechanisms to warrant them come and put this matter before court. We as the advocates think that this matter is not properly before the court, and therefore pray that the court finds the same and directs that the matter be taken back to the KMPDU board to handle it. That will be all.
Thank you.
So, of course, I'm on record for the family, which is the true victim of the offense that is in the charge sheet. It is standard procedure that when a party is summoned to court, that they must obey the court orders. What we saw today is that there was an acknowledgement that the accused persons were aware of today's proceedings, because why else would they have sent an advocate to court? The reason the court made the directions that it has just made are to balance, as you had in court, to balance the scales. So in that regard, there being no orders from the High Court suspending the procedures before the Magistrates' Court, what is left is for the accused persons to present themselves to court and to take plea. And if you had my submissions before the court, if any person is aggrieved with the proceedings before this court, they know which court to approach. So no orders have been issued by the High Court suspending any proceedings before this court, and therefore tomorrow at 9 a.m. we'll be here, and the accused persons shall take plea. And if anyone is aggrieved with the decision to charge or the proceedings herein, they know the right forum to approach. So a lot of things that unfortunately you saw transpire in court are just marketing language. The law is very clear. If you are given a court order, a valid court order that has not been set aside or reviewed or struck out, then you must obey it. And that is the example we need to show Kenyans. When a court summons you, you attend. You don't have to, even if you are aggrieved with the fact that you are summoned to the court, you come to that court, subject yourself to that court, and give whatever reasons you have for your disagreement with whatever orders have been issued. So I think we will be here tomorrow. We are expecting to have the accused persons take plea, and then we take on the necessary steps. Of course, on the side of the victim, we are happy that we have reached this stage, but it is our prayer that whatever is going to be done before this court is done with speed, so that, at the end of the day, healing is important. They need to close this chapter and move on. Because at the end of the day, there's a child without a mother, there's a man without a wife, and there's a family without their daughter. So that should always be our focus. Justice for the family. I would ask a very simple question. Which profession has been charged today? It is 3 individuals who are alleged to have committed offenses. And if they do believe that they are innocent, let them attend this temple and sanctify themselves. Because at the end of the day, we like to attach or suck in people who are not relevant or have not been subjected to this court to try and get public sympathy. But that's not going to happen this time. Someone has lost their life. Someone is the reason behind that loss of life. And if you do believe that you are innocent, please come and prove to us that you are innocent of whatever it is that you've been charged. But anything else outside that is just hot air. Yeah. Well, I sadly do not have any evidence that they are in operations. I have been told that they did open their gates and they did withdraw the challenge they had to their closure. But I think it would be better for you guys to take a little drive there and see whether or not they are operating. But I do believe upon taking plea, we shall be trying to ensure that they do not operate at least until these proceedings here are concluded. That would be one of our pursuits. Yes.
Hiyo yenye ameongea nje hapana, yenye ameongea tuko kimya.